Я единственное, вот вас я хорошо слышу. Когда я разговаривала с Кристианом, я не очень хорошо его слышала. Я немного боюсь за вопросы.
Дарья, у нас есть микрофон здесь, и мы его просто попросим задающих вопросы подходить к микрофону.
То есть, если будут вопросы, то лучше говорить с микрофоном. У вас сейчас какая страница? Первая, да?
Да, первая страница.
Окей, то есть я могу начинать.
Если вы позволите, мы откроем мероприятие и передадим вам слово.
Да, конечно, открывайте мероприятие.
I will do this extremely quickly because of the delay. Ankara team, welcome. So I just quickly announced Moscow Pre-Move Open, and I'm very happy to see everyone here. During next 3 hours, we will discuss what I believe concerns these mood participants most of all this year, emergency proceedings. So do not hesitate to ask all your emergency concerns to Daria and Christian in the first session, and our panelists from the second session will join us. This event is annual one, and from 2012 it is hosted by Wyden Case. That is why I pass the floor to Wyden Case partner who will welcome you here.
I think I won't take a lot of your time either, so I just wanted to say congratulations and I wish you good luck. And I hope this is a very useful event for you and this will help you when you participate in the actual competition. Strangely enough, I have taken part in this, but it was more a help to the written submissions only, and I was concentrating more on just on the international competition. But I do think it's a great opportunity both for professional development and also for personal development and for meeting interesting people. So congratulations and welcome.
Yeah, thank you very much. I think we think Wyden Case for hosting this event every year. We will have today 2 sessions, 4 panelists, and let me introduce our distinguished panelists. Daria from Paris, International Court of Arbitration at ICC. Daria, thank you very much for agreeing to speak here in spite of extremely short notice. We deeply regret you are not here with us. Probably next year you will manage to come here. I will help you with this. We believe you will come. You would love here in Moscow. And we thank Christiana Schauer, professor at University of Graz, and also a partner at Andreas Reiner and Partners Law Firm. Christian came from Vienna. He will reveal this. He is a coach of the University of Graz team, and he will, I suppose, reveal some secrets of this Yemen problem. And
no secrets anymore.
No secrets after third, fourth prelude, but still some secrets about Yemen. After all the presentation, we will have a welcome dinner at the restaurant next to the office. And I must say that nothing would be possible, neither this discussion nor Moscow Remote, nor any social events without our sponsors. Without our main sponsors, Wyden Case, Cleary Gottlieb, Steele & Hamilton, and Monastyrsky Zuba Stepanov and Partners, and our supporting sponsors, who are Morgan Lewis, Leadings, and Baker & McKenzie. With this, I kindly pass the floor to Daria. Daria, if you have any technical difficulties, just let me know. I'm here waiting for next slide word, and I will help you.
Hello everyone, I'm very happy to be here with you, even virtually, but I'm happy that more and more Russian teams take part in this mood, and that the arbitration in Russia becomes more and more popular, notwithstanding some difficulties that we are incurring now. I would like to say that I'm a bit sad to speak English with you. I would prefer to speak Russian, but as the language of the Bismuth is English, and we have invited the English speakers to our conference. So I will make my presentation in English. Alessia, could you please go to the first page with the summary of my today's presentation?
Yes, it's here.
So as you can see, I will speak from the point of view of the International Court of Arbitration. So I will basically shortly present the rules. And I will explain how it works. If after that you have any questions, I will be happy to answer. I can say that today, as of today, we have 15 applications for emergency arbitrators. Unfortunately, in our team, in Eastern European team, we didn't have any, but this year, last year in 2014, we had an application for the pre-arbitral referee, which is very rare because the pre-arbitral referee existed for 24 years, and for 24 years we have had only 14 applications. So I consider myself very happy that in one of my cases I had the pre-arbitral referee, and I can compare it to the emergency arbitrators provisions. So as you can see, first I will speak about the purpose of the emergency arbitrator, very shortly because the purpose is clear. Then I will speak about the conditions for filing emergency arbitrator applications, and then explain how it works in practice. And I think that the last point is the most interesting for you because it can give you some inside view of the emergency arbitration provisions. So now we can go to the second slide. Alessia,
Yes.
could you please
Yeah,
go
yes,
to
yes.
the second slide? I'm trying to be elegant. So you went to the second slide, right?
Yes, it's here.
So the purpose of emergency arbitration. Of course, the purpose of emergency arbitration is to protect legitimate interests of the party. The party normally files the application when the party thinks that it's so urgent that no other means can protect their interests. So the ICC Court of Arbitration, in order to be competitive and to suggest to our users the alternative to state courts, put in place different proceedings. First of all, the proceedings pursuant to Article 28, provisional measures, and Article 29, which is of our interest today, the article on the emergency arbitrator. Now we can go to the next slide.
Yes.
So Article 29 contains the provisions on their application for emergency arbitrator. So the conditions are that the applications are made before a request for arbitration is filed, but it contains additional condition which I will explain later. It can be filed simultaneously at the same time with the request for arbitration, and it can be, in any event, be filed only before the transmission of the file to the arbitral tribunal. So it may be before or after the arbitral tribunal was constituted. And in any event, the parties retain the right to apply for the state courts for interim or conservatory measures. Now I'm going to the next slide. So you can see on this slide that The ICC rules contain several provisions protecting the parties' interest. For instance, Article 23 of 1998 rules on conservatory and interim measures, Article 28 of 2012 rules, which I already explained, and the ICC pre-arbitral referee procedure rules. As I said, in our team, we had ICC pre-arbitral referee procedure rules in a case involving a Russian party, and it was very interesting because the request has been already sent, but claimant needed to protect its interest and to make sure that the funds that respondent has the funds to secure the arbitral award. So it applied for the pre-arbitral referee procedure rules, and we dealt with it successfully, and the order of the referee has been issued in these proceedings. So it's one of the possibility to protect the rights, but it's not that useful and secure as the emergency arbitration rules, and I will explain why. There was a decision of the French courts in 2003, and the French courts decided that the pre-arbitral referee order was not equal to the arbitral award, and basically said that it was a contractual obligation of the parties which they could or could not fulfill. And so it couldn't order the one party to comply with the pre-arbitral referee order. And now the commentators to 2012 ICC rules say that the emergency arbitrator order will be different in this respect, because there are a lot of chances that the emergency arbitrator's order will be treated, at least by the French courts, as an arbitral award, and so there will be a possibility to enforce it. I don't know how it will be in other jurisdictions, but at least the French practice is like that, up to date. And now I will go closer to the rules and explain how and when we can find the provisions on the emergency arbitrators and how to articulate these provisions. So as you can see on my slide, the emergency arbitrator provisions are contained in Article 29 of the rules, and also in Appendix 5 on emergency arbitrator rules. Now we can go to the next slide. The conditions for emergency application. So the emergency arbitrator procedure cannot be applied if the arbitral tribunal is in place, if the parties are neither signatories to the arbitration agreement nor successors, and this is very important. And if the arbitration agreement was concluded before the 1st January 2012. If we go to Article 29(1), we can see that I should ask for the excuse here because there's a mistake in the slide. Well, the first provision should be read before the transmission of the file to the arbitral tribunal. I don't know, I'm really sorry for that. So Article 29(1) sends us to Article 16 on the transmission of the file to the arbitral tribunal. So the arbitral tribunal may be in place, but it should be before the transmission of the file to the arbitral tribunal, which is a bit different, because there may be a lapse of time, very small, but still before the setting of the arbitral tribunal in place by the Secretary General, for instance, and the day when the Secretariat sends the file to the arbitral tribunal. The second provision, that the parties are neither signatories to the arbitration agreement nor successors. This sends us to Article 6.3 of the 2012 rules, which provides for the decision by the Secretary General or the court as to whether the arbitration can proceed. So if we have difficulties in understanding whether this arbitration can proceed with the parties at question, these emergency arbitration provisions cannot be applied. And the third condition is very simple, so it doesn't apply to the arbitration agreements concluded before 1st January 2012. It was done in order to secure the parties' agreement and not to give them bad surprises. There was a practice of the court already on this last provision. For instance, in one case where the emergency arbitrator application was sent, the contract was signed in 2011 but amended in 2012. So the President, while accepting the application for emergency proceedings, decided that the application may be transmitted to the emergency arbitrator, but emergency arbitrator himself decided that the claimant's application is not admissible because the contract itself was still concluded in 2011. And the fourth condition for the emergency application is that the parties should not agree to opt out these provisions. It's my next slide, Alicia. So here you can see the standard and suggested clause, which contains this opt-out provision. So if you don't want the emergency arbitrator provisions to be applied to your future arbitration, you would specifically indicate it in your arbitration clause. So, the wording may be different, but we always suggest the parties to use a very simple language, not to complicate things. So basically this one sentence, the emergency arbitration provisions shall not apply, is sufficient. It's better not to invent other things which can complicate the proceedings after. Now we can go to the sixth provision. Fifth condition is if another pre-arbitral procedure was agreed. So you cannot apply to the emergency arbitrator if another pre-arbitral procedure was agreed. For instance, pre-arbitral referee, which I was talking about before. The sixth condition may seem very funny, but in reality it may complicate the things a lot. For instance, imagine that you filed an emergency arbitrator application and you have really very short terms. So you know that the respondent may move the assets and it's really urgent. But the problem is that if you didn't pay the $40,000 required for these proceedings, the Secretariat will not be able to transmit the application to the emergency arbitrator, so it may delay things. In practice, I can say that even if the Secretariat receives the application without money, we start working on this application. So it means that we are looking for the arbitrators, we are putting everything in place. But if you don't pay this $40,000, unfortunately, we cannot go on and send the application to the emergency arbitrator. So now it's also important for the Russian parties because unfortunately French banks, for instance, or Swiss banks, when they accept the payments from the Russian parties, they have additional checks, additional internal checks, and it can delay receipt by the ICC of these application fees. So you should take that into account and have it in mind before sending the application. It's really, I'm really sorry to speak about that, but you should be aware of that in order to plan your arbitration tactics. So the seventh condition is in the rules. The rules say that if an emergency arbitrator application was filed, the applicant should file a request for arbitration within 10 days which follow. And so if the request for arbitration wasn't filed, this procedure may be terminated by the president of the court. So now we go to probably the most useful part, because it's the part how does the procedure work. So as I've already said, while filing the application, you should always pay the $40,000. And my advice, which I always give to the parties, for instance, in my cases, when they call in any event, I say everything is in the rules, and that's true, because before filing any application, any request for arbitration, it's very easy to go to the rules. There is a Russian version of the rules on the site. There is English version, so you go to the rules and everything is in there. So basically, after we received an application, the president of the court will assess whether the provisions of Article 29 are met. So when we say the president of the court, you probably know that now the president of the court is John Beachy, who will give his place next summer to Alexei Moore. And so when we say the president of the court, of course, it's the team in charge of the case which prepares the report, and the president of the court signs this document after checking as well where the provisions of Article 29 are fulfilled. So if these conditions are met, we notify the application to respondent parties. There was already a case where applicant claimant didn't want the Secretariat to notify the other party, saying that it may endanger the future of the arbitration. Well, unfortunately, even if we understand the problems, we should still apply the rules and still notify the application to the respondent party. So after that, now I went to the following slide. The president of the court appoints the emergency arbitrator. What does it mean, appoints the emergency arbitrator? So as we don't have this procedure or any list of arbitration, like for instance the CAS, So what we do, it's the secretariat, the team in charge of the file, people who think about who can be suitable for this case. It depends on several factors. For instance, it depends on the place of arbitration. It depends on the language of the proceedings. It depends on the applicable law or on the parties to these emergency proceedings. Which is also interesting to know is that the provision on the nationality of the arbitrator doesn't apply. For instance, if a normal arbitration and you have a French party, it's been 20 minutes already. I will try to finish it as soon as I can. So if you have a French party versus the Russian party, normally in any arbitration, ICC arbitration case, as a sole arbitrator, we will appoint a person who is not national of France or the Russian Federation. This provision doesn't apply in emergency arbitration provisions. So we can, for instance, choose a Russian national for this case. So then we can see that the provisions on impartiality and independence of the arbitrator apply. So as well as the provisions on the challenge of the emergency arbitrator. What we can remember here is that the challenge on the emergency arbitrator may be decided even after the emergency arbitrator ruled and issued his order. For instance, if the emergency arbitrator issued his order and then the challenge was accepted by the court, the order loses its legal force. So after making sure that the emergency arbitrator doesn't have any conflict of interest, the Secretariat notifies to the parties the appointment and transmit the files to the emergency arbitrator. So then the emergency arbitrator establishes timetable for the proceedings and sometimes schedules the hearing. The hearing most of the time takes place by video means because the emergency arbitrator should issue the order in very short terms. So now I went to the slide which says that the emergency arbitrator decision shall take the form of the order, which should be reasoned. And as I've already explained, we hope that the order of the emergency arbitrator will be treated by the majority of state courts as their arbitral award with all consequences of it. I mean the enforcement and the enforceability of the award. So in his order, as you can see, the emergency arbitrator must determine whether the application is admissible, whether the emergency arbitrator has jurisdiction, decide on urgency measures, and fix costs. As to the costs, here you can see the difference with the normal arbitration proceedings, because normally it's the court which fixes the costs and not the arbitrator. Here the arbitrator fixes the costs himself or herself, but it cannot be more than 40,000 in the majority of cases. So 10,000 will be the administrative tax of the ICC Court of Arbitration and 30,000 for the fees and expenses of the emergency arbitrator. The order, it's the next slide, Alicia. The order should be made within 15 days. Then it is notified directly to the parties, and the parties are bound by their emergency arbitrator's decision. which is interesting is that the arbitral tribunal is not bound by the emergency arbitration decision and can take its own decisions on the issues which have been already dealt with, which is logical because the arbitral tribunal has a lot more elements and proof than the emergency arbitrator. So the next slide is the conditions when the order ceases to be binding. So as I already said, it ceases to be binding if the court accepts the challenge against the emergency arbitrator, if the president of the court terminates proceedings because the request for arbitration was not filed, if the arbitral tribunal rendered its final award, or if the claims were withdrawn and the arbitration terminated before the final award. As my time has expired, I will just go to the last slide, Alicia, the colorful one.
Yes.
So the last slide shows us what happens from the moment of application until the order is rendered. So as you can see, the maximum is 18 days, but in several cases that we have already had, the emergency arbitrator issued the order more quickly, and the parties were very happy with that. I can say that up to date, the parties are very happy with the emergency arbitrator's proceedings, and it seems that it will be more used and more useful as well for the parties as a pre-arbitral referee proceedings. That's all that I wanted to say. It's been a bit not logical from my point of view, probably from the German point of view as well. But if you have any additional questions, I will be happy to answer and to show more on using the examples. Thank you very much.
Thank you very much, Daria. Thank you very much. Please stay with us next 30 minutes to address.
Of course, I will stay. It's scheduled. It's in my schedule.
Thank you. And I'm happy to pass the floor to Krista and Ashala. Krista, thank you. I will now give me a second to fix your presentation.
Dear colleagues, first of all, I want to thank Olesya for the kind presentation and for the invitation to come here to Moscow with my team of students who are a bit late, but they will join us in the evening. And I also wish to thank White & Case and all the other law firms who are participating for their kind hospitality. I believe it is very difficult to follow up on Daria's presentation because Daria has told you everything you need to know about the ICC emergency arbitrator for the V-smooth court problem. Therefore, let us just review perhaps another time the V-smooth court problem and see the significance of the emergency arbitrator and its order for our case. Here you can see that Party Global Mirrors, which you know, and which has affiliate. It is a trader, I believe, of raw materials, and it has affiliates in many countries of the world. And one of those affiliates is Valkan Kolta. It's incorporated in Equatoriana, and it is a limited liability company that has only a minimum stated capital of 20,000 powers of coltan are very limited, as you know. This is now the emergency order of Miss Jean Wu becomes relevant. In her decision, Miss Jean Wu considered first of all that Balkan and Mediterranean are both signatories of the arbitration agreement. And then she dealt with Article 21 of the contract, the provision which you know, which states that if emergency relief is needed, the courts of the place of business of the opponent of the applicant shall have exclusive jurisdiction, but she was of the view that this provision does not exclude the jurisdiction of the emergency arbitrator. Then she dealt with the emergency in the case at hand. She found that Mediterraneo was already negotiating with other possible clients, and therefore the measure was so urgently needed that it could not await the constitution of the arbitrary tribunal in her view. She also dealt with one prerequisite Daria has referred to, which was the good argument case on merits. She was of the view that prima facie there may be a contract over 100 tons of coltan. And lastly, she dealt with the irreparable harm condition. And she said that, well, Balkan will not be able to supply coltan to its own customers, and that will be very harmful for Balkan's reputation as a coltan trader. So she rendered the emergency order, but this did not help the parties very much. I mean, it helped, of course, the claimant, but it also led to an escalation of the conflict in that Mediterraneo made a claim for damages and costs against Balkan and against Global. Why against both parties? The first argument was that according to Mediterraneo, Global, the parent company, negotiated and performed the contract, and therefore became a party to the contract and also a party to the arbitration agreement. And the second argument of Mediterranean is that the Global and Balkan form a group of companies, and that therefore the group party is effectively Global. So this is a short overview where you can see what is the relevance of the ICC emergency arbitration provisions for our case. Now, let me refer to the background and to the purpose of emergency relief. I would submit that there is no effective justice system without emergency relief. I mean, as we all know, it follows from the rule of law that no party is entitled to practice self-defense. And I would submit that this rule is even more important in urgent situations. Otherwise, everyone can say that he or she is in a situation of urgency and can practice self-help. And therefore, it is essential that any justice system, be it the state court, be it the arbitral tribunal, can offer interim measures of protection. This principle is almost universally recognized. For example, we have Article 17.1 of the Untitled Model Law on International Commercial Arbitration, which states that the arbitral tribunal has the power to render interim relief. We have also Section 17 of the Russian law on international commercial arbitration, or for example, Section 1468 of the French Civil Procedure Code. And this is a very far-reaching provision in that under the conditions which the arbitrary tribunal determines. Here we do not even have any guidance as to what are the criteria for the ordering interim relief. So this is a very broad power of the arbitrary tribunal under French law. And now we go to Italy, and we have section 818 of the Italian Civil Procedure Code, which states in one sentence: gli arbitri non possono concedere sequestri né altri provvedimenti cautelari. In Italy, an arbitrary tribunal is not allowed to seize property, and it is not allowed to order interim relief. Now you might say, this is a very special situation, but there may be certain reasons, and we should understand that the power to order interim relief is something very particular. It is not self-evident that an arbitrary tribunal can do so, because you, as an arbitrator, have to decide on a prima facie basis, and the decision can have very far-reaching consequences. So there is something behind the view of the Italian legislature that private arbitrary tribunals should perhaps not be empowered to render interim relief. But even in Italy, there is an exception to that rule regarding corporate law disputes, when an arbitrary tribunal has to deal with the nullification of a company resolution. It can order that the validity of this resolution is provisionally suspended. Therefore, we have in principle a situation where an arbitrary tribunal is, where other international arbitrary tribunals are allowed to order interim relief, and now you understand perhaps that this is not self-evident. It is a big achievement. This has been accepted only in the last, let us say, 10, 20 years, and you, as an arbitrator, have to be very careful when a party requests interim relief. On the other hand, interim relief is urgently needed, and I would submit not only during the arbitration procedure, but even more so before the start of the arbitration. Very often this is a hot phase in a dispute between the parties, and the dispute escalates before the commencement of the arbitration, and then interim relief is all the more needed, but not always available. And not it is, of course, only available from the state court, because the arbitrary tribunal cannot act prior to its constitution. But the intervention of the state court is not desired, because you may submit that if parties agree on arbitration, they have a common intent, the state courts shall not and never and under no circumstances deal with this matter. And then